We're recording now.
Thank you. Welcome, everyone, to the monthly roundtable, co-sponsored by the Association for Conflict Resolution of Greater New York and the City University of New York Dispute Resolution Center at John Jay College of Criminal Justice. I'm Maria Volpe. I'm a professor here at John Jay College. This morning is our 299th gathering since 9/11, when I started this monthly breakfast and the listserv that many of you are a part of. If you're interested in joining the listserv, please send me your email address. I have put mine in the chat and we'll put it in again shortly for those of you who have joined since we got started this morning. These sessions were in person from 9/11 until March 2020 at John Jay College. Since April 2020, since the pandemic, we've been meeting on a monthly basis, mostly online. We had a few in person, but for the most part, we have been a virtual community and anticipate continuing as a virtual community. These sessions are recorded and the recordings are posted on YouTube, as well as the websites for the co-sponsors, ACRGMY and the CUNY Dispute Resolution Center. And Nikki will post the YouTube link in the chat. Each month, these breakfasts are, we still call them breakfasts, these roundtables are organized and facilitated by a wonderful group of colleagues, including Matthew Latimer, Nikki Porofsky, Sherston Pugh, Chloe Choi, Elizabeth Grossman, and Alex Yaroslavsky. And we're really thrilled every month to have our colleagues near and far share with us their amazing work. And this month, we're thrilled to have with us David Hoffman, who's been a thought leader for years. I'm going to turn it over to Nikki, who will introduce David more appropriately. Take it away, Nikki, and thank you so much, David, for joining us this morning.
Thank you, Maria, so much. And I have a bit of a long-winded introduction, but it's in part because we have such an impressive speaker, and in part to help people filter in so that they don't miss any of our feature act. Um, One of the things that I appreciate the most about this roundtable breakfast community is that we're really willing to engage conflict not only as a professional discipline, but as a profoundly human experience. We're not just interested in settlement rates or clever techniques. We're interested in what happens inside people and inside ourselves as well. So when conflict hardens and identities become threatened, when emotions intensify and movement suddenly feels impossible, this is where we dig in. And that brings us to today's topic, impasse. All of us, every dispute resolution practitioner, student, person knows this feeling. When the conversation narrows, the energy in the room changes, people begin circulating around familiar arguments with increasing certainty and decreasing curiosity. Sometimes it's a strategic move, but often it's psychological. Something deeper is happening beneath the stated positions. And very few people in our field have explored this terrain with the depth, rigor, humanity, and practical wisdom of today's speaker, David Hoffman. David is the John H. Watson Jr. Lecturer on Law at Harvard Law School, where he teaches mediation, diversity and dispute resolution, and collaborative law. He is also a mediator, arbitrator, attorney, and founding member of the Boston Law Collaborative, where he has worked for decades with family, business, employment, and organizational disputes. Before founding the Boston Law Collaborative, David spent 17 years as a litigation partner at Hill Barlow, which has given him firsthand experience with both adversarial systems and the search for more constructive alternatives. And even before that, he was a woodworker. So he has some additional hands-on experience coaxing immovable materials into things of utility and beauty. He's a past chair of the ABA section of dispute resolution, a graduate of Harvard Law School, and a former editor of the Harvard Law Review. But what makes him especially important to so many people is the role he has played in expanding the intellectual and emotional vocabulary of mediation itself. Long before it became commonplace to talk openly about these kinds of things, he was speaking of emotional intelligence, mindfulness, trauma, vulnerability, mediator presence, and the inner life of conflict. And he's helping bring those conversations to the center of the field. Many of us know him for his influential co-edited volume, Bringing Peace into the Room, which challenges mediators and lawyers to think not only about strategy and negotiation and process architecture, but also about authenticity, emotional awareness, and what it means to remain fully human in moments of conflict. This contribution has had a lasting impact on mediation practice, and I highly recommend the book to everybody. Um, but today, we will be discussing David's newly published book, The Art of Impasse-Breaking in Mediation, which offers more than 60 different impasse breaking tools and interventions for mediators, lawyers, negotiators, and anybody at conflict. What makes the book really exciting is that it's not just a catalog of techniques. It really is a delving into why these interventions work psychologically and what shifts when movement becomes possible. So, one of the most innovative dimensions of David's work is his application of the internal family systems model, or IFS, to mediation practice. My aunt is actually an IFS grief counselor, and so I'm very familiar with this as the parts kind of work. It offers a really fascinating framework of helping us to understand the different parts we all carry within us: protective, fearful, managerial, wounded, reactive, and how they may simultaneously want resolution and also resist or be vulnerable to change. For mediators, this is a really rich territory. Um, I think that what makes it especially interesting today is that it's not just a lecture. This is an opportunity for us to engage with these ideas that David has in his book. And so I encourage everybody, as the presentation continues, as you have ideas and thoughts, add them to the chat. Share your ideas, share new ideas, share your reactions to any of the ideas that David is speaking about. So this is part of what the Roundtable Breakfast does well. David is, I think, poising himself for volume two, so we can all be part of this remix. And really, this is a space where scholarship, practice, experimentation, reflection, and community wisdom can generally interact. So we are truly fortunate to have with us someone who has helped to shape these conversations for many years and for many years to come. Please join me in warmly welcoming David Hoffman. David, the floor is yours.
Thank you, Nikki. Thank you, Maria. Um, Thank you to the other organizers and all of you. It's great to be among friends and fellow mediators. I'm going to share with you some thoughts about impasse breaking, particularly the psychological dimensions of it. Um, and I'm going to share with you some material that is not in the book, but I hope will be in the second edition. And as Nikki said, it'd be very helpful for people to put in the chat impasse breaking ideas that aren't in the book. And in the second edition, I'll be sure to credit people who share ideas that make their way into that edition. Before putting up slides and a few New Yorker cartoons, which I usually use when I give a talk. Alex, I think you said that you've got a poll that's ready to go. This is a poll that will help us, help me get a better sense of who's in the room in terms of background and the types of cases that people do, and the extent to which people are familiar or not familiar with internal family systems as a way of thinking about what makes people tick. So Alex, over to you if you could launch the poll.
So the poll should now be launched for anybody who's driving or can't access it. The first question is, what are your role or roles in dispute resolution? And you can check more than one. The options are mediator, lawyer, mental health professional, financial professional, teaching, and other. The second question is, what area or areas in your dispute, in what areas is your dispute resolution work? Again, multiple choice, multiple options: family, business, employment, labor, personal injury, community, mediation, or other. And three is, what is your level of familiarity with the psychological model known as internal family systems, IFS, developed by Dr. Richard Schwartz? You can check several of them. Again, never heard of it, but not super familiar. Attended one or more workshops about it, or read one or more articles about it. I have taken a formal training in IFS. You use it in your professional work, or I have been in one or more therapy sessions in which therapists used IFS. So thank you, everybody, for responding to these initial table setting poll questions. It helps David get a sense of where everybody is.
Hey, so Alex, I'm noticing that number of responses has slowed. We have 172 people who have 187 people responded to the poll question. So thank you, everybody, for uh, responding to the poll questions. And Alex, do you want to share the screen to show the responses, or are people able to see them? There we go. So this is really a wonderful mix of professions and somewhat even mix among family, business, and employment and community. And in terms of IFS familiarity, we've got 4 people who've taken a formal training and 8 people who use it in their work. And a lot of people who have never heard of it or have heard of it, but perhaps are not very familiar with it. So let's go back to, okay. So I'm going to share some slides, and the heads up I want to give you is I'm going to turn off my video for a moment, but it will come back on momentarily because I'm going to put on the video in the slides. If all of this works, we'll see. In the meantime, you're going to see an avatar of me wearing exactly the same outfit I'm wearing right now. And okay, so now with any luck, I'll be able to share the screen and go through a bunch of slides. And then I'll come out of the slides every now and then for some Q&A and discussion. So hopefully right now you're seeing me in the lower right corner of your screen and seeing 2 people shaking hands. And now you get to see a few New Yorker cartoons. So here's one of my favorites. That's Maria and Nikki out there on the precipice, and that's me with the spear at the moment. So if your needs aren't being met, just speak up and it will take care of the situation. The second cartoon, I don't know if you can see the caption on these cartoons. It's at the bottom of the screen. Never ever think outside the box, says the cat owner to the cat. I have a cat and say the same thing. But here we're going to think outside the box. It's one of our superpowers as mediators. Not only the box of substance, but also the box of process. And then finally, the idea of beginner's mind, a Buddhist concept. The caption says, one monk says to the other, "My mind is especially empty today," which is not a very Buddhist thing to be boasting about. So the concept here is, and this is very consistent with internal family systems ideas, that we all have judgy parts of our mind that get in the way of learning about new things. So, and those judgy parts are good. They're no bad parts but we don't want them to be overactive. So I'm going to invite us all to invite the judgy parts of our mind to take a step back and create some spaciousness for some learning parts. The agenda, I'm going to focus very directly on psychological dimensions. There are other dimensions too. There are game theory dimensions, and there are various kinds of problem solving that we mediators do in order to break impasses. I will, after introducing some ideas, talk about the idea of bargaining at three tables, which is the way I experience mediation. I'll share with you a few specific impasse breaking tools. And after some Q&A, I have a concluding story from Ken Cloak that I want to share. So that's the plan. But I'm going to start with a story. I'm guessing that a number of you know the story of the 18th camel. It comes from Iran from the 18th century. Bill Urey brought it into a more contemporary frame in his book, Getting Past No, and also a TED Talk that he gave. Here's the short version of the story. And I hope its relevance will become clear in a few moments. So this is a story about inheritance rights. And in this particular situation, the parents have died and left their three adult children the following allocation of their estate. The parents' will says that the oldest of the three kids gets half of the estate, and the middle child gets 1/3, and the youngest gets 1/9. And the problem is that the estate consists of 17 camels. And you can't, without slaughtering one of the camels, which is not the ideal solution, you can't divide 17 camels in half or a third or a ninth. And so the solution, of course, is to hire a mediator. And in this particular case, and I'm taking some liberties with the story, I suppose, the mediator arrives riding her own camel, and she does the math, recognizes the dilemma, and she decides that she's going to donate her camel. So now the parents' estate consists of 18 camels. And now this works out rather well. The oldest gets half, which is 9 camels. The middle child gets 1/3, which is 6 camels. The youngest gets 1/9, which is 2 camels. And for those of you who are working your calculators as I speak, you'll recognize that when you add 9 and 6 and 2, you get 17. And so that leaves 1 camel, which the 3 adult children give back to the mediator. So what's going on in this puzzle? Well, if you get all mathy about it, which I did when I tried to figure out what's going on here, what we recognize is that when you allocate the estate in this way, there's an unallocated portion. In other words, a half and a third and a ninth isn't a whole. If the ninth was a sixth, then it would be a whole. But the parents made a mistake, evidently, because they left 5.6% of the estate unallocated. So what happens when you allocate the unallocated portion, allocate it proportionally, what happens is that everybody gets a bigger slice. And so while the oldest was going to get 50%, now the oldest gets 52.9%, and the middle and youngest of the siblings each get a slightly higher percentage of the whole. So my thesis, if maybe that's too grand a term, but the point that I want to make is that in mediation, we are often in a situation where there's some surplus value. It may be the reduction of transaction costs. It may be the acknowledgement and recognition that people exchange as part of a transformative, mediation process. There may be some mutual exchange in which that makes the parties better off. If you want to read more about this, the 17 animal inheritance puzzle, there's a Wikipedia article about it, and also Bill Urey's TED Talk, which is up there. And of course, everyone here will be you'll have access to the slides because I'll be sending out a PDF. So there's an image of the book published by the American Bar Association. And as Nikki mentioned, there are 60 and then some impasse breaking techniques. I think it's chapter 2, has the process interventions. Yeah, chapter 2 has the process interventions. And if you look at the screen and there are any on here that you have a particular question about, please, jot it down. Then in chapter 3, I have 30 substantive interventions. And I've been giving some talks about this book and picking out some of the techniques to talk about. And that I want to share with this group. I feel like I'm among friends, so I can be very candid about the experience of writing this book, and focusing on psychological dimensions. I sent out a draft of this book to a group of mediator friends, and I had a very humbling experience that I'm going to share with you. And that is that I received an email from a dear friend and colleague, Larry Susskind. And it was a wonderful, thoughtful email. And what he said in this email is, he said, "This is terrific that you've put together this long list of impasse breaking techniques. But here's the book that perhaps you should have written, or maybe you could edit it and make it more like this." He said, "I think you should reduce dramatically the number of tools and techniques listed and talk about the process of matching the tool to the type of impasse." He says, "That's the key." And I thought, darn, he's absolutely right. And yet here I've written this whole book, and I'm about to ship it off to the American Bar Association. But Larry's point has stuck with me. And so in the second edition of this book, I'm going to do exactly what he suggested, which is I'm going to spend more time talking about how do we know which is the right technique. And Nikki, in your very kind introduction, you said that I do speak to that, and it's true. I do speak to it some, but I think that's the secret sauce that we mediators are looking for, and so much of it is intuition. So this talk this morning with everyone here is my attempt to respond to Larry Suskind's very thoughtful point and share with you, well, how do we know? And so let me pose a question. When there's an impasse in your mediation cases, how many of you would say that the cause of the impasse, more often than not, is a psychological or emotional factor? And what I'd like you to do is maybe I'm going to stop the screen share for a moment and just look around the gallery view screen. And if the answer to that question is yes, please raise your hand physically or electronically. And I'm just going to kind of scan the room. And wow, there are a lot of people here. 239 people. So that's a lot of gallery view screens because it only loads 49 at a time. Okay, well, thank you for answering that question. Um, and that's been my experience also, that the psychological dimensions are really critical. Now, let me see if I can go back to sharing the screen. So that being the case, one might wonder, what kind of training do we give mediators in figuring out how to discern what is the psychological or emotional factor? By the way, the literature, scientific literature about this is pretty clear. Jonah Lehrer, in his book How We Decide, tells near the beginning of the book the story of a patient, a medical patient named Elliot, a pseudonym, who was a successful business person and family man, who had neurosurgery to remove a tumor from the orbitofrontal cortex, which is the part of our brain that connects logic and emotion. And this case involving Elliot, after the surgery, he continued to test at a very high level for IQ. His memory was intact, but his emotions were gone. And interestingly, Elliot found that without access to emotion, even the most trivial of decisions was enormously hard to make. And so this was an incidental finding of this particular medical case, but a very evocative and I think important one, namely that while our logic circuits are very much in play, or we try to encourage people to bring their logic circuits to bear in mediation, their emotions are absolutely critical. And rather than, at least in the training that I got as a mediator, emotions were often described as the steam in the kettle, and we have to release the steam before we can pour a cup of tea and settle the case. And so emotions were treated as sort of not the enemy exactly, but as interfering with the process. And what we now realize is that emotions are absolutely critical. Let me ask you to put in the chat the answer to this question. In your initial training as a mediator, approximately what percentage of the focus was on emotional and psychological factors? And if your training was anything like mine, I imagine that it was not, there was not as much training on psychological and emotional factors as I now realize would have been useful. So I'm just going to see if I can do this, take a quick look at the chat while I'm talking. I see some people saying very little, some people saying a lot, 30, 40%, 5%. Thank you for these, less than 10%. Thank you for these responses, very useful. I want to share with you something that I learned at a conference some years ago. I was on a panel, it was on pedagogy of negotiation, and I was on a panel with a mediator and mediation trainer from Austria. Some of you may know Mario Patera. And he said to me, in Austria and in Europe generally, but he said specifically in Austria, when we learned that in the United States, you get 30 to 40 hours of mediation training and then you go mediate, he said, we think that's laughable. And I said, well, how long are the trainings in Austria? And he said 365 hours, except if you're a lawyer or a mental health professional, 220 hours. So I said, whoa, that's a lot. What do you do in all that time? And he said, we talk about the psychology of mediation, and not just what's going on with the parties, but at least as much what's going on um, with inside the mediator. So that's one of the reasons why internal family systems is a useful frame. At least I find it useful because it focuses a lot on what's going on inside the heart and mind of the mediator. By the way, I should just say in passing that when we talk about internal family systems, we're not talking about families, we're talking about individuals and the family-like relationship that our various parts have with each other. Um, so, um, for example, when I woke up this morning, the alarm went off. There was a part of me, this was my first internal negotiation of the day, maybe same for you. There was a part of me that wanted to hit the snooze button, and there was a part of me that says, nope, need to get up and make the coffee and get going. So we have these polarizations, we have these internal dialogues all the time. And our internal part system is really pretty elaborate for all of us. Now, let me offer a caveat. Not every mediation involves emotion, or at least, I mean, it may involve emotion to some degree, but emotion might not be central. So I'm going to tell a little story about myself, which is a slightly embarrassing story, but we're among friends here. So this is a case in which I was counsel. It was an insurance coverage case, and we used mediation to settle it, and it did settle. My client was a nonprofit, and it had been defrauded by two of the leaders of the organization. One of them was the CEO. The other was another important figure in the organization. And the losses that resulted from this misconduct were in excess of $2 million. Fortunately, the nonprofit had an insurance policy with coverage limits of $2 million. Unfortunately, the insurer canceled the policy and therefore denied coverage. Why? Because in the insurance application, which was signed by the CEO, she said in the application that she had no knowledge of any potential liability or losses. And that turned out to be untrue because she was directly involved in the misconduct. But there is, as some of you may know, there's legal precedent out there that says that even though the insured is the organization and not the CEO or the person who signs it, the insurer can deny coverage or cancel the policy if there was a misrepresentation. So as counsel for this nonprofit, I talked to the new CEO because the previous one was dismissed. And here are my instructions. They said, what do you think we can recover? The law seems to be against us on this. And I said, well, I don't know what we can recover. They said, well, what's it going to cost us to have this mediation for your fees and cost of the mediator? And I said, $10,000. So this was back in the 1990s. Might be a little more now. But in any event, my client said, if you can settle this case for even $1 more than $10,000, dollars more than the cost, you have our permission to settle it. So we show up at the mediation, and I make my pitch about how this is really going to be a bad precedent for the insurer. It's going to look terrible for them. Here, this nonprofit with a very honorable mission was duped by their own CEO, and they're denying coverage, which the nonprofit paid for year after year after year. And suddenly when they need them, the insurer is gone. And the first offer after I make my big spiel is $100,000. So my task, emotionally, so speaking, was to have a complete poker face. Actually, worse than that. I had to look stricken, like how could they possibly, and I actually said in the mediation, I was one of those obnoxious lawyers that we mediators generally find frustrating. I rolled my eyes with contempt for their $100,000 offer. I moaned and groaned. And of course, the mediator was doing caucusing. So a lot of my acting, outraged and indignant, was for the benefit of the mediator. But I did a little bit of it in joint session also, so they would get the message. And the mediator went back and forth. And by the end of the day, we settled the case for $300,000. It was one of my greatest successes as an actor and also as a lawyer. And this nonprofit was one of my favorite clients. So I was really pleased that we got a settlement that, had the case gone to trial, we would have had an uphill battle. I don't think we would have won it. But the point I'm making is that the insurer didn't make an emotional decision. I think they made a cost-benefit decision. And of course, on our side for the nonprofit, we were making a cost-benefit decision. And, you can overplay your hand. We mediators have often seen lawyers and clients overplay their hand and lose a settlement that would have made them better off by being too stubborn or too inflexible. So I knew once we had that first offer of $100,000, this case was going to settle. There was no doubt in my mind. The only question was where on the scale. So I described this case as one in which the sole focus was what is the expected value of this case? What is the expected outcome? What's likely to happen in court? And the insurer didn't have an emotional stake in it whatsoever. To me, this kind of case is the exception that proves the rule. So when we talk about looking for the 18th camel in the psychological dimensions of mediation, I want to begin by saying I'm not talking about the DSM, the Diagnostic and Statistical Manual of Mental Disorders, published by the American Psychiatric Association. I'm not interested in pathologizing the psychological and emotional dimensions. What I'm actually really looking for is a set of tools that are intuitive and non-pathologizing and empowering. And we have a number of them in our field, and I'm listing here on the slide some four that I'm going to talk about. And as I said, they all have in common these features of being intuitive, non-pathologizing, and empowering. So let's talk first about System 1 and System 2 thinking. Many of you know the book Thinking Fast and Slow by Daniel Kahneman. Wonderful book. He's a Nobel laureate, a deep thinker in psychology of negotiation and behavioral economics. And the basic premise of the concept of System 1 and System 2 is that our brains, our minds have two kinds of circuits. We have the fast circuits, which are intuitive and automatic. In System 1, we know how to ride a bike. We don't have to do a logical analysis of the physics of it. We get on the bike, we have muscle memory, or same with, say, driving a car. Or navigating the hallways of a building that we've spent a lot of time in. But if we're in a building that we've never been in before, we may need to use System 2 and read the signs and figure out the logic of how we're getting from where we are to the place we're trying to reach. But the second time we go to that building, we may be using System 1 because, oh yeah, I know how to get to the room that I'm trying to get to. So let me describe a case where and I should mention that most of the work that we do in our daily life is System 1 because it's very efficient to have these kind of automatic, responses. System 2 uses up a lot of resources, and So our emotions are over here in system one, our logic circuits are over here in system two. So I'll tell you a quick story about a mediation involving the founder of a foundation. This particular person is a doctor. When the case came to me, he had been voted off the island, so to speak. The foundation kicked him out. And he had created this foundation with money that he personally donated. And the foundation had an important charitable mission. But he became more and more irascible as the years went on. And finally, the board just gave him the boot. And they put him on notice. They kind of warned him that he was being difficult. But he kept at it. And so they terminated his relationship with the foundation. Now you can imagine how upset he was, how emotional he was. I said, "What do you really want?" He said, "Well, I want the current CEO and the chair of the board. I want their heads on a platter, so to speak." I don't think he meant that literally, but he wanted them terminated, and he said, "And I want to be reinstated." And I said, I don't think that's going to happen. So let's talk about what is attainable. And toward the end of the day, there was $750,000 on the table as a settlement offer. And he said, "No way, absolutely not." And I was pretty sure that this 750,000 was probably the top dollar. It was probably the most that was going to be available. And we explored all kinds of non-monetary solutions, putting up a big plaque with his name on it, featuring him on the website, doing all kinds of things that wouldn't have cost money but might have been useful. I said, "No, I'm not interested in any of that." And so I said, "Well, let's talk about the $750,000 offer." And I said, "What I'd like you to do is to make a T-chart." They had yellow pads in the room, and I said, "Make a T-chart. And I want you to put on the left side of the T-chart all the reasons why accepting $750,000 would be a bad idea. And then on the right side of the T-chart, make a list of the reasons why accepting that offer would be a good idea." And he made the lines on the pad, and he picked up the pen to start writing. And then he looked up at me and he said, "I get it." He said, "It's hard to be angry and write out all these different reasons." And the case went on to settle. And what he was doing there was I was inviting him, encouraging him, and giving him a methodology for how to switch from his emotional, reactive, angry system one thinking and use his logic circuits in system two. I wasn't trying to make the emotions bad or wrong. I was simply trying to get the other circuits engaged. And so in the internal family systems model, we would say, so you've got these angry firefighter parts or gladiator parts, and you also have these, manager parts, the logic parts. Now, I want to do a little shout out to Bill Eddy, who many of you know, and I read his books, maybe trained with him. He's got a question when he's working with high conflict people that I think is a great question. And that is after they're fulminating and, expressing their outrage, kind of the way I did in the insurance coverage case. And the mediator asks, "So what is your proposal?" And that's a lovely question, a really helpful question, because it gets people to shift out of system one thinking to system two thinking. It's hard to formulate the specifics of a proposal with the circuits that are carrying the anger. A second psychological model that I think creates an opportunity for finding the 18th camel, so to speak, is the idea of core concerns, which comes from a wonderful book, Beyond Reason, by Roger Fisher and Dan Shapiro. And some of you may know this is a very widely read book in our field. The core concerns that they identify are affiliation, appreciation, autonomy, role, status. That doesn't necessarily exhaust the possibilities of core concerns. But what they do, and this is a really clever move, sort of in terms of understanding what makes people tick. Rather than focus on the emotion, it might be anger, it might be fear, or some other emotion, they talk about what are the concerns that are driving that emotion. And so I'll tell a quick story about a mediation that happened recently in my living room here at home. I'm broadcasting from my home office in Acton, Massachusetts. This was a family that just happened to be in the Boston area on a weekend. And so I was rather suddenly thrown into a mediation with no memos, no background. It was a rare opportunity with this far-flung family to meet in person. And I thought it was a dispute about estate planning and inheritance issues. It involved a father who is in his 70s and three adult daughters. And two of the daughters brought spouses with them. The problem was that their father was in the early stages of dementia, and he was still, competent to sign a will or update his will. And what the daughters wanted, the three sisters are very tight. They wanted equality of treatment under the will. They didn't want one of them to, receive more than anybody else. And they wanted transparency from their father about the estate planning, which is a very reasonable goal. And they wanted to be kind of an advisory committee to help out as he made this transition. And so let me share a quick mediation technique. I just that morning I thought to myself, I've never met these people. I know very little about them. How am I going to get to know them and hopefully create some trust? And so I thought, aha, I'm going to ask about their family values. And so this could have backfired, I suppose, but it worked out pretty well. I said, let's go around the circle. There's 6 of you. I'd like to hear from each one of you one family value that, a value this family holds dear. And please tell me how you first learned that this was a value of this family. When did this first, come to your awareness? And oh my gosh, the stories were lovely. They told about, honesty. They told about loyalty. They talked about love. And so I got to hear what was best about this family. And after we did the go around, we kind of got down to brass tacks. And what I realized was that for the dad, there was a real struggle internally between his desire for autonomy and his concern about his role in the family as the father of these children, brought these children into the world, and now his role, you could call it status, I suppose, but was being threatened by their wanting to advise him about his estate planning. On the other hand, there was a part of him that had core concerns about affiliation and appreciation, love and connection, and wanting to be appreciated by his daughters. And they were kind of mad at him because he had not been completely honest with them about the estate planning. And by the end of the day, they signed a document agreeing to transparency and agreeing to having the daughters as an advisory committee. And one of the moments that helped bring about that settlement was when I said to the dad, in the presence of the daughters and two of their spouses, I said, Dad, there's a part of you, I am hearing that there's a part of you that really values your autonomy. And he said, absolutely. And I said, and there's a part of you that values the love and connection you have with your daughters. He said, absolutely. I said, I think we all have an inner mediator, and that mediator within can listen to these different core concerns, these different parts, and come up with a wise solution. And can feel that in yourself? And he said yes. And that helped him manage the internal negotiation of these core concerns. Difficult Conversations, a very important book in our field. I'm guessing many of you, if not most of you, have read the book published by Doug Stone, Bruce Patton, and Sheila Heen. And in this book, the authors talk about the three conversations that are taking place when we are having a difficult conversation. One is what happened that led to us having, a difficult conversation. Second, what was the emotional impact? And third, what are the identity issues that come up around this difficult conversation? I'm going to talk later about bargaining at three different tables. I think these three different conversations are also really useful to think about. And sometimes we're going back and forth. As our colleague, mediation colleague, Brad Honoroff says, every mediation has a beginning, a middle, and an end, but not always in that order. And so we often jump around from one of these questions, one of these conversations, what happened, to identity issues. Let me tell you a quick story that illustrates the point about difficult conversations, and particularly identity, because we have these exiled parts in us, the ones that carry around fear, shame. If you can answer the question, I am not blank enough, that's an exiled part. Some part of us that feels some sense of unworthiness. And so in this particular mediation, and these are pictures of Desmond and Claire. And in fact, they made up their names. But this is an actual case. It was a divorce mediation, and it was a battle over money. They had figured out the parenting issues rather quickly. And they were really at an impasse over the money. And at one point, Claire turned to me and said, I'm concerned that you'll think I'm greedy. So this was, in other words, her identity. She was having an identity quake because her soon-to-be ex-husband was a heterosexual marriage. Her soon-to-be ex-husband was treating her like she was being unfair about allocation of the money. So I said to her, and this is, again, using the rubric of internal family systems, I said, I know there's a part of me that worries about money, and it sounds like there's a part of you that worries about money. And my suggestion is that we should honor those parts of us, because imagine if we didn't have a part of us that cared about money. Life would be very chaotic and we might run out of money. But I said, Claire, I know that there are other parts of you as well. There's a part that cares deeply about the kids and wants to be a friend, friends with Desmond after the mediation is over, and many other parts. So so everyone should please mute if you're not in the conversation here. So I said, I don't think you should feel embarrassment about having a part that cares about money. We all do. And I could see her relaxing, but I also saw Desmond busily taking notes while I'm talking. So I said, and I thought I was going to get the rebuttal, where now it's Desmond's turn. He said, well, actually, I think Claire is greedy. He didn't say that. I said, Desmond, I see you're making a lot of notes. He said, yeah, I said this, what you just said seems really useful. I'm going to think about that. And I thought, oh my gosh, this is the kind of moment that we mediators or teachers love, when we share something that actually is useful to people as they sort of make their way in the world and through this conflict that they're in. So basically, the concept is to destigmatize the parts that people may be feeling some embarrassment about. Let's now talk about an internal family systems model itself. And the basic concept is pretty simple, but often very useful ideas are simple. And this one is that people have parts. Now, this isn't a completely novel concept. Freudian theory has id ego and superego, and Eric Berne has adult, parent, and child. And there are many other psychological models that have parts. But the particular description of parts in this model I find quite helpful. By the way, it was created by Dick Schwartz, who's written a number of books for clinicians, but he also wrote this book for a lay audience, which I highly recommend, Introduction to Internal Family Systems. And or you can go to the IFS Institute website. There's abundant material, including video lectures, if you want to take a deeper dive. And this IFS model is discussed in the book, The Art of Impasse-Breaking in Mediation, but it's not the main focus. I think in the second edition there will be perhaps more. I think there will be more attention paid to it. So, what are these parts that in the IFS model? Well, I mentioned one, exiles, the parts of us that we don't usually share with others because they carry around our pain, our fears, and our shame. And I'll give you an example of a exile that I've been carrying around for more than 60 years. This part of me, this exiled part, arose when I just had my driver's license. I was 16. I was really excited about driving. I loved driving. And I would drive my grandmother to the mall so she could do some shopping. I loved my grandmother and deeply. And when I showed up one time, she said, David, you are consistently late. She, by the way, was unfailingly prompt. She said, when you come later than you said you were going to come, it makes me feel like you think your time is more valuable than my time, or more important than my time. And oh my gosh, that cut me to the quick, because here was my beloved grandmother telling me, in effect, that I was a bad person because I was chronically late. And she was absolutely right. My management of time was terrible. And over the years, I've gotten better about it. And one of the reasons why I've gotten better is because I carry around this exiled part, and I want to protect myself from re-injury. So I try to show up on time. So we have these manager parts. So I have a manager part that focuses on time, on what time is it, and to get me to appointments on time, because I have my grandmother's voice in my head. She lives there rent free, and so managers have proactive strategies to prevent injury. But in conflict, we often encounter firefighter parts, and these are the ones that are reactive. When someone in a lawsuit, let's say, accuses the other person of being discriminatory or bigoted or guilty of some kind of fraud or breach of contract, that accusation may be experienced in their exiles because they're being told they're bad and wrong. And so they react to counteract the pain of that injury. Eleanor Roosevelt once said, no one can make you feel bad about yourself without your permission. And it's a very wise comment. And so the firefighters are the ones that we're essentially giving the other person permission to upset us. And And it may not be a voluntary choice. In fact, it's usually not conscious. But when they wound and exile, um, uh, then we are in effect giving them permission to hurt us in some way, and so we tend to react. Now, so these are the kinds of internal parts, and we have many, many, many parts, and sometimes they straddle the boundary between managers and firefighters, but all of them carry burdens. They are overactive in some way if our system is out of kilter, which of course it often is when we encounter people in mediation. Our self energy isn't a part. It's our heart, our spirit, our soul, various wisdom and religious traditions have different words for it. It's our seat of consciousness. It's who we are when all these parts step back and we can experience ourselves without the agenda that our parts have. Now, this model is useful. I find it useful in so many ways. One of them is so that I can be more self-led. When I can get my jangly, intrusive parts to take a step back and be fully present with another person, self-energy, when we access it, can be contagious. And sometimes it means, for me, being a little bit vulnerable or just being compassionate and curious. Those are some of the characteristics of self-energy. When we can access those qualities, we create a space where other people can do that too. And maybe they can be more curious and compassionate about the other person with whom they are in conflict. So those are three of the ways that this can be deployed in our mediation space. So let me describe a sex discrimination mediation where I saw this metaphor of the mediator within, our self-energy, work out in a very helpful way. So the plaintiff in this case was an upper-level manager. She had been canned and replaced by a man. They gave him a different job title. They said her position was being eliminated, and she said that was BS. This guy they hired was doing exactly the same thing she had been doing, but with a different title. And she had an excellent lawyer. And by the end of the day, there was $250,000 on the table. And it was pretty clear that that was the company's final offer. And so the question for her was, the case hadn't been filed in court yet. It looked like it was going to be maybe 2 or 3 years, maybe 4 if there was an appeal. And here she was, the primary earner in her family. And so I met with her and her lawyer in a caucus session. She was trying to decide whether to settle the case. And so I said to her, I sense that there's a part of you that wants to fight the good fight here for women's rights and to fight discrimination, gender discrimination. And she said, absolutely. And I said, I'm also sensing there's another part of you that is very concerned about paying the mortgage and putting food on the table because of the importance of your economic role in your family. And she said, absolutely, that too. And like as with the father and his 3 adult daughters, I asked her if she could, I said, I think we all have this mediator within who can listen to these different parts. The one that wants to fight the good fight, the one that worried about paying the bills, and come up with a wise solution. And I could see her going within. I could see her pausing and really accessing her inner mediator. And she said, I know I need to settle this and move on. And with that, she stood up and her lawyer stood up and they gave each other a hug. And so stood up and they gave me a hug and the case was done. And what that case did for me was it helped me understand better how in breaking impasses, I don't have to have an agenda as an advocate for settlement. I used to think that. I used to think that was my job. Parties each advocate for their point of view, and I am in the room to advocate for settlement and explain all the reasons why settlement would be a good idea. And when we do that, it's a natural thing for people to say, well, maybe, but here are all the reasons why settlement wouldn't be a good idea. So I don't want to have that kind of adversarial, agenda-laden conversation. I'd much rather have a conversation in which I'm not trying to twist anyone's arm. I'm just wanting them to make a decision that they're going to look back on, and to use Larry Suskind's terminology, that the resolution was fair, efficient, stable, and wise. If I can help them make a self-led decision, then I feel like I'm carrying out my responsibilities as a mediator. I'll tell you one more story, and this is from one of my earliest mediations. I hadn't heard about the internal family systems model at all. But I now look back at this case and see how some wounded exiles were very much present. So this is a case about an elderly lawyer, and I'm going to put air quotes around the word elderly because even though this was 30 years ago, he was the age that I am now. So, and I don't want to think of myself as elderly, but I think by any measure I am. In any event, he was in his 70s, and he was being sued by his clients, a group of his clients, because he's sold them stock on a foreign stock exchange, and the stock became worthless. Now, it wasn't like he was taking advantage of the clients. He bought the stock too. He thought he was doing them a favor by buying a large quantity of stock and selling shares to them. But the clients were very unhappy. And there was a huge settlement gap. There was no insurance for this claim. And when I met with this elderly lawyer in a caucus session, and we were trying to figure out what to do because the parties were so far apart, he started talking to me about his life. And he said, David, you never met me before, but he said, I'm so troubled by this case. I haven't even told my wife about it. And if she knew about it, it would kill her. And he said, another thing that you don't know about me is that I'm an alcoholic. I haven't had a drink for 30 years. So I'm a recovering alcoholic. He said, but I wake up each morning, and the first thing I do, even though it's been 30 years since I had a drop of alcohol, the first thing I do is I fall to my knees and I pray for the strength not to take a drink that day. And now, in my peripheral vision, I'm seeing his lawyer, who is a much younger, a relatively inexperienced lawyer, literally rolling his eyes and look and trying to communicate to me like, I don't know where this conversation is going, but clearly my client doesn't, has kind of wandered off into the weeds here because his alcoholism has nothing to do with this case. There's no allegation that he did this because he was drunk. He's been sober for 30 years. Why is he telling, this is all communicated by body language, facial expression, and an eye roll. And I was a brand new mediator. I didn't know what to do with this information. I really didn't. But I listened and I tried to bring, my best empathic self and said, I said to the elderly lawyer, it sounds really hard. And he said, yes. And he paused and then he stood up. And so I thought, well, I guess the mediation's over. So he walked over, I stood up and he walked over toward me and he held out his hand and he said, so we shook hands and he said, this is a really great thing you're doing here with this mediation stuff. He said, tell them I'll accept their offer and we're done. And I was like stunned, like nothing had happened that was in my, a mediation strategy and impasse breaking technique. I just sat and listened to this gentleman. And but what was going on inside him was that he had some exiles that were burdened by the thought that he had not been a good friend to his clients, that he had violated ethical duties. He had violated the securities laws, and he was a lawyer. He should have known better. To be sued by your own clients, of course, triggered insecurities, feelings of unworthiness in him. And for someone, be it a mediator, it could have been someone else, I suppose, to sit and listen and witness his pain enabled him to rally his manager parts and say, you know what, I need to settle this, even if it's going to cost me more than I think I can afford. I've got to do it. And I guess my point here is that awareness of people's parts can be really useful. Now, I'm going to share with you in detail a recent case involving multiple impasse-breaking tools, one of which is internal family systems. But it also involves some techniques that are discussed in the book, including range bargaining and a mediator's proposal and case evaluation. So this was a case in which a CFO had been terminated, and he was actually a founder, one of the founders of this company. And the company had good reason to fire him. He had done a terrible job as a CFO. They brought in an outside auditor, and the outside auditor said, I've never seen such a mess financially. But the problem was that his employment contract said that before you fire him, you have to give him a chance to make a presentation to the board as to why he shouldn't be fired. And you have to give him a period of time, I think it might have been 30 days, to cure the default. The company hadn't done either of those things. The company's lawyer said, no, you can just fire him. And so anyway, the CFO lawyered up and filed a lawsuit with a demand for $321,000, which is what the employment agreement, the severance provisions called for. They didn't fire him appropriately, and then with appropriate notice and opportunity to go to the board. The company responded with a counterclaim saying, this guy was so negligent, if this goes to trial, we're going to win money from him. So the mediation began 9:30 in the morning. And although the plaintiff didn't want to move off of their demand, they said, we want an offer first. I persuaded them that, yes, the ordinary convention here is that you you present a number that's less than your make whole number. And they did, 250,000. And the defendant, the employer, came back with 25,000 and offering a dismissal of the counterclaim. Now, on their own, the plaintiff's side decided, in consultation with me, that they were going to use range bargaining. So some of you may be familiar with this. It's a really useful technique. The plaintiff said, we'll come down from 250 to 175 if they come up to 100. And on the defense side, they said, no, we're not willing to come up to 100, but we'll move from 25 to 40 if you come down to 120. Then the plaintiff decided not to respond with a range, but to put a number on the table, 160, and then the defendant moved up from their 40 to 70. That was a healthy move. But then the plaintiff only moved 15,000, and so they only moved 10,000 to 80. And then the plaintiff only moved 7,500. You can see they're tapping the brakes here. And then when the defendant only moved 5, you can see the increments of movement are getting smaller and smaller, and those curves don't intersect. So at that point, the plaintiff said, you mentioned, David, that if we wanted a mediator's proposal, that you would do it. And I said, if the other side wants it, then sure. And they said, fine. Now, here's something that I do that I didn't used to do. If there's going to be a mediator's proposal, I dust off some PowerPoint slides, and I actually show them in each room or jointly if they're together. I got this idea from Eric Green, who's a fabulous mediator. And so let me show you the actual slides that I show the parties, and then I'll tell you what the mediator's proposal was. So I explained to them that a mediator's proposal is different from case evaluation. Case evaluation is a prediction of what the court will do. Mediator's proposal is a prediction of what the parties will do. So my role in making a mediator's proposal is not to say this is what I think will happen in court, but rather here's where I think there's a zone of possible agreement. And the ground rules are, I'm sure, familiar to many, if not most of the people in this Zoom room. All the parties have to want the proposal. The mediator talks with the parties about what other terms, confidentiality, tax treatment, ancillary terms, and usually in a mediator's proposal, there's one issue that's open, which is the dollar amount. But you have to clear out the underbrush, so to speak, of issues that might be confounding variables. Then I make the same proposal in both rooms in caucus session, ask the parties not to respond right away, but to think about it. And I also talk about a time limit. Because if you don't create a time limit, they might say, well, we need 24 hours or we need 48 hours. So we agree in advance about a time limit for response. And then I go back to each caucus room and find out whether the response is yes or no. And I report the responses only if there are two yeses. So that means each side can take the risk of saying yes. The other side will never know unless they too said yes. This works in about 80% of the cases where I use it. And another 10%, it works because after a failed mediator's proposal where one side said yes and one side said no, they show their cards and we complete the bargaining. So I suppose you could say on average, and I've talked with lots of other mediators who use this, about 80 to 90% of the time, this results in a settlement. Now, I show these slides also. I said, imagine a case, fictional case, where plaintiff has demanded $6.5 million, defendant is offered $250, and by 6 o'clock, the parties are stuck at $2 million and $1 million. What kind of mediator's proposal might you make? And I said that in that situation, I know for certain that the plaintiff would settle at $2 million. That's 100% likelihood. And I also know that there's 0% chance that they'd settle for $1 million because they've rejected it. And likewise, the defendant is 100% likely to settle at $1 million, 0% likely at $2 million. Where do the lines cross? Where is the place where if you, giving a mediator's proposal, if you move the number to the left or the right of the crossover point, you're reducing the overall chance. That's the chance of settlement. So the answer to that question might be over here or it might be over here. It's also possible that there's no zone of possible agreement, that these lines of resistance or willingness to settle don't cross. So I show them these slides, and I showed them in this case from a few months ago. And I made a mediator's proposal, and they also wanted a case evaluation. The proposal was $111,250, which is the exact midpoint of these two numbers. Now, mediator's proposal, as I said, sometimes is to the left of the midpoint, sometimes to the right of the midpoint. In this case, my intuition was they each needed to move an equal amount in order to be willing to settle. Why a case evaluation? Well, the defendant employer, they were going to sue their law firm, their old law firm, which had given them bad advice about how to terminate the CFO. And they wanted not only a proposal, but also the reasons why a proposal might be useful, because they could show it to their old law firm's insurance carrier. There's one other feature of this case, and I'll tell you the outcome in just a moment. When I met with the CEO, she said, and this was before the mediator's proposal, when they were back in the 70s and 80s here, I said to her, she said to me, just so you know, David, we will never get to 100,000 in this case. And I said, why? And she said, because it wouldn't be fair. And I said, well, hang on a sec. I want to understand something better. You're anticipating that you'll be able to collect whatever you pay in settlement from your old law firm's insurance carrier, their malpractice carrier. And she said, absolutely. And I said, so if you paid $100,000, it wouldn't actually cost your company anything. And she said, that's true, but it's still not fair. And I said, you know what? I get it. I hear you. There's a part of each one of us that cares deeply about fairness. And it goes beyond just the, dollars and cents. It's an issue of principle. And I said, as a species, it's turned out to be a really good thing for us Homo sapiens to have that part that punishes greed and insists on pro-social action. And I sense, I said to the CEO, that there's a part of you that is concerned that in the next round of venture financing, which you are facing, it would be really unhelpful to be in the middle of litigation with your former CFO and have information come out in the public record about how the books were unreliable and needed to be cleaned up after terminating the CFO. And she said, you're right. There is a part of me that's very worried about that. So I said, okay, well, we all have a mediator within that can help, that can listen to the part that cares about fairness and the part that cares about practicality. And let's see where this case goes. And each side accepted the mediator's proposal. And by 8:30 that evening, we had drafted a memorandum of understanding. Now, the reason why I want to mention that the colloquy with the CEO is that word fair. When I first got trained as a mediator, I was told, don't use the four-letter word fair because it just gets everybody riled up and everyone has a different conception of fairness. And I have found that trying to explore each side's sense of fairness and try to get them to moderate their commitment to fairness doesn't work very well. Instead, the internal family systems model says, honor thy parts. There are no bad parts. The part that cares about fairness is a good and valuable part. It may be a little overactive sometimes, and we need to think about what other parts are there. By the way, there was only one joint session in this case because the parties couldn't stand each other. And so we had 18 separate caucus sessions. But as you'll see, there were 4 joint sessions with the lawyers. That's something I didn't used to do when I first started mediating, which is to have a joint session with just the lawyers. That worked out really well. The lawyers got along and really helped us settle the case. The other secret ingredient is I brought my dog Bella. Bella is a rescue golden retriever from Serbia. And she literally is batting 1,000. Every single case I've brought Bella to, the case is settled. The parties may dislike each other, but nobody dislikes a golden retriever, at least not that I've met. Now, obviously, I have to ask in advance, are there any dog allergies or dog phobias? But so far, knock on wood, there haven't been. And Bella helps me settle cases. Now, I have 2 final points that I want to make. And I mentioned the idea of bargaining at 3 tables. So this idea, bargaining at 2 tables, comes from Bob Mnookin, Andy Tulamello, and Scott Peppett in their book Beyond Winning. And what they point out is that in mediations, people are often going from one table, the table of expected value, the most likely alternative to a negotiated agreement. And when they get frustrated at this table because they disagree about what's going to happen in court, then we mediators can get them to shift, or maybe even from the beginning, to the table of interest-based bargaining, where hopefully they can resolve it. But sometimes people go back and forth, like maybe they haven't been able to figure out some kind of trade that makes both sides better off. And they say, well, why should we be so, flexible and reasonable when we're going to win in court? So that's how the conversation has this sort of beginning, middle, and an end, but not in that order quality. I think that there's actually a third table. That third table is the table of emotional exchange and connection. That's the table where I met the elderly lawyer who told me about his struggles with alcohol. It's the table where I met the father with the three adult daughters who cared about his autonomy, but also cared about other things. So we as mediators can be guides here. We can help guide people from one table to the other, and we can normalize the fact that there are three different conversations that are worth having in any given mediation. And so the kinds of impasse breaking tools that we use at these three different tables, for expected value, we use case evaluation, mediator's proposal, range bargaining, et cetera. For interest-based bargaining, we might use buyouts, earnouts, profit sharing, trades of various kinds. And for the relational, emotional interventions that are the ones we use at the third table, they may be things like storytelling or apology or cross-looping, where the parties demonstrate that they've heard what the other person said, or acknowledgement and validation. And I guess so. That's one point. And the second point is that we can use psychological tools. We can bring an 18th camel to each of these tables. In other words, for example, with a mediator's proposal, we're trying to deal with reactive devaluation. The parties devalue each other's proposals. It's a common cognitive bias. But we can work with those parts. So, there's a part of you that's skeptical of the other side's good faith and their proposals. And there's a part of you that may recognize that what they've proposed is simply a step in a process that hopefully will lead to a resolution. We can certainly use the IFS parts model when we're talking about relational interventions. So as we diagnose the settlement barriers that we're trying to address and to break an impasse, we need to think about at these various tables, is there missing information? Often with expected value or even table number 2, interest-based bargaining, more information is needed, or there may be a missing party. Or we may need to change the players. Who's sitting at these tables? Do we want to have a caucus session with just the parties and not the lawyers, or just the lawyers? Or who would be able to have the best conversation? I was told that I can put in a plug for something as part of this, and then I'm going to stop and see if there are questions. And that is that next year, 2027, I'm going to be doing for second time a training called the Self-Led Lawyer and Mediator for the Internal Family Systems Institute. And if anyone's interested in knowing more, just send me an email. This will go up on their website probably in July. It'll be every Wednesday from February 3rd to March 10th for 3 hours. And it's a chance to take a deeper dive into the IFS model. And with that, I'm going to stop the screen share, open the floor for questions, comments, reactions. And I have told the organizers, I think I've told the organizers that I'm willing to stick around after 10 o'clock if anybody has unanswered questions. So now I'm going to put my video back on. Bear with me for a sec while I do that. And the floor is open. And if there's anything in the chat that I haven't seen, Sadia, I see your hand is up.
Yeah, thank you so much. This was incredibly insightful, especially with your examples. I was wondering if you could speak a little bit about, you shared a lot of examples in which, you kind of acknowledged the different parts that were present, how you kind of witnessed them and how they were maybe in tension with each other. I'm curious if you've ever run into situations where you did that acknowledgement and kind of that conversation with the part and kind of name the part, but that maybe wasn't enough to kind of nudge someone in one direction or another, if they maybe stayed stuck in impasse. I'm curious how you maybe handled those situations when the part was maybe like a little bit more persistent.
Yeah, that's a great question. Thank you. This is not the rubric that I would use in every case. First of all, I have to establish some relationality, so to speak, before I could even venture to talk about people's parts. Although it's very common. This is not like psychoanalysis. We all talk about our parts. Part of me, you know, wanted to order the French fries, but another part of me said order the salad. So uh, that I find that people are pretty receptive to that conversation, but some people are not. I'll give you one quick example, and then see if this is responsive. I mediated a case, business breakup, two brothers, and one was he was a CPA, he was very analytical, he had no interest in psychology. And his brother, the co-founder of the company, was very psychologically oriented, was a Buddhist, and was really interested in talking about the emotions. And as I caucused from one room to the other, I had very different conversations with them. And so the parts language would have been really useful with the Buddhist brother
Mm.
and not with the CPA brother,
Mm.
as it happened. But it doesn't mean we can't settle the case. So, yeah, by the way, is the correct pronunciation of your name Sadia or Sadia?
It's the way you said it the first time, Sadia. That's right.
Okay.
Thank
Sadia,
you.
thank you for your question.
Yeah, thank you. I appreciate it.
David, I just
Other,
wanted to jump in and just so some people have to hop at 10. So
yes.
thank you for everybody for joining us. Thank you for so much information. And I just wanted to make a brief pause to give everybody the space to leave if they need to, and to also say we'll continue to record so that this Q&A session will be on the YouTube channel that people can catch later. So I just wanted to give that little interlude, and then we can continue for a few more minutes while you're still available. And anybody, there's quite a few some hands raised, so people clapping, and there's just great feedback. It's been really dense and rich and thoughtful and super interesting. So I hope you're seeing the explosions of applauds, applaudissements on the screen. Does anybody else have any other questions? I'm sorry to interrupt your flow. I just wanted to put
No,
in a pause for people and encourage. So there's a bunch more that are coming up on the
I
screen.
see. I see, Christine, you raised your hand.
Why, thank you, David. It was a wonderful presentation. Thank you so much. You had said that you would be able to send out the presentation that you just gave in the slides. So I did put my email in the chat. I would really enjoy like taking my time reading through it and looking at your references. Also, your IFS class in February. Thank you. How would we be able to find out more information about that?
You could send me an email and I'll put
Okay.
your name on a list and contact you as soon as the registration goes up. And
Okay.
or you can check periodically at the IFS Institute website or the Boston Law
Okay, I wrote
Collaborative
that down. That
website.
part I wrote down. So thank you
Okay,
so much.
you're welcome. Thank you.
Thank you.
Lorna, I see your hand is up.
Hi, David. Awesome presentation as usual. Great to see you. So the interlay, I think, is as long as humans are involved in a conflict, even if there isn't emotion, humans by nature have emotional parts of them, right? So, and we do as ourselves as mediators, right? So I think a lot of what you're saying is use this for yourself as well as for the parties to maximize it, even if the conflict of itself doesn't have emotion, that would just add another layer. Am I off base in thinking
No,
that?
you're absolutely right. I remember one mediation that involved 20 people. It was a family trust situation. And one of the parties came up to me, took me aside and said, Hoffman, you've done something in this case that I didn't think was possible. He said, you've made a really bad situation even worse. And and I thought, this guy is trying to, you know, um, get my goat. And the tools that we've been looking at in this past hour were the tools that I needed to uh, manage the jangly parts inside me, the defensive part, the angry part, the part that wanted to punch him in the nose. And so, yes, this is all really pertinent to our remaining non-defensive, non-reactive, even though inside we've got these parts that are, you know, jangly. So is that responsive, Lorna, to your
It
question?
is. And then my question is, in this world of AI, how do you see that layering on or separate or?
It's a great question. There's there's a short section in the book about using AI for option generation, which I think is one of the cool things that I've seen AI do. Of course, you have to protect the confidentiality of the parties.
Right.
You know, if you put in a fact pattern and you ask AI to think about, quote, think about what are some of the emotional dimensions of what's going on here. ChatGPT and Claude and Google Gemini, all three of them do a pretty good job of discerning, kind of reading not just the words but the music. But obviously, it's no substitute for our intuition. It's hard to use it in real time. So I think the use case for AI in terms of the emotional dimensions of conflict is yet to be made. But of course, AI is in its infancy. And so it may be that people will get accustomed to integrating it into our Zoom and video conferencing. And so we have a panel that's giving us advice, real-time advice as mediators. You know, David, you missed a nuance in what that person just said. You might want to go back and revisit that. That's a conceivable use, although it feels a little creepy and scary, perhaps. So time will tell. We've gotten used to all kinds of things we never thought we'd be used to in terms of technology. I see Carmen and
Thank you.
Asha, and then Robin in that order.
David, hi. Thank you. Thank you so much. I particularly appreciated that you were able to name something that I struggle with in every mediation, namely that there's that emotional component, but there's also that practical component. And just the way you brought it together, it was like, to me, it was like this aha moment. And so, thank you for that. I also wanted to hear your thoughts. I've recently read an article that was written by the founder of the one of the mediation theories, Baruch, and I'm spacing on his last name.
Baruch Bush.
Right, Baruch Bush. Thank you so much. And so, what I feel it's important to do a lot of reading and a lot of understanding and really kind of feel comfortable to help the parties from so many different perspectives. And yet, he's so gung-ho and also there's the guy who graduated from Brown and he's so gung-ho, like, it's got to only be one way and, you're a moron if you do anything else. And so I was wondering, like, what do you say to those people when, it's like they feel God forbid you should caucus, right? Because, and then
Right.
it's
Got
sort
it.
of like, but that's what people
Yeah.
need. So how
Yes.
do you respond to them?
Okay, great question. Thank you for that. I'm going to tell you about a book. I think the author's name is Jeffrey Kotler, a therapist. It's called The Complete Therapist. And what Kotler did in this book was he tried to figure out what's the secret sauce that Freud, Jung, Adler, Rogers, some of the great clinicians and theorists, what was their secret sauce? And he concluded that it wasn't the particular methodology that they used. What they did was they developed theories and forms of practice that played to their strengths. They had, kind of a unique type of intuition. And I think that's what we mediators do. We come up with theories and forms of practice that fit our skill set. And we say, that's the way, and I tend to be more eclectic than that. I think each of us in mediation need to find our way and draw from whatever tools. I'm not making a claim in this Zoom gathering that the internal family systems model will work for everybody. It may not work for some people. It works for me. It kind of fits my way of relating to people. But I mentioned the other tools, core concerns and difficult conversations, et cetera. In the book, I talk about nonviolent communication. All of us mediators need to have lots of tools in our toolbox. So that's how I would respond to the claim for orthodoxy. I don't think we are far enough along in our journey, and maybe we'll never get to a place where there's a right way to mediate. Carmen, is that responsive?
Yes, thank you so much. I'm so grateful.
Sure. Now, Asha, I don't see your tile on the top of my screen, but please unmute if you're.
Thank you so much, David. Can you hear me okay?
I can.
Wonderful. I apologize. My camera's off. I'm at the vet with my puppy, but I could not miss your talk and it was incredibly insightful. My question is your personal stories definitely shined a light and highlighted some amazing practices. What is something that you use as an 18th camel, per se? Like, what is a trick up your sleeve that you can give all of us that
Sure.
uses that works as your 18th camel?
Okay, so here's something I didn't used to do when I first started mediating, and it helps me find the 18th camel. And that is that after having a joint session where we talk about the process, unless there's a compelling reason to stay in a joint session, in commercial employment cases, I'm not talking about divorce now, but cases where parties have lawyered up, my default, subject to their saying, no, we don't want to do it that way, is I meet with each side separately twice. In the first round, I talk with, let's say, the plaintiff, and I tell them in advance, both sides, I'm not going to talk numbers in the first round. I just want to get to know the parties. I want to hear what's in the impact of what's going on. I want to hear their story. And then I go in the defendant's room, do the same thing. When I come back to the plaintiff's room, we get to the numbers because I find that people are very impatient. They want to get to the numbers as soon as possible. And I want to get to know them as soon as possible. So we have to balance those two agendas. But by giving people notice in advance, that's how I'm going to do it. It causes them to be less worried about the fact that we've reached 11 o'clock and there are no numbers on the table, because by lunchtime there will be. And I will have gotten to meet and know the parties in a much more up close and personal way. And that by itself can sometimes be the 18th camel. But when it isn't, it's often those initial meetings that allow me to have a heartfelt communication with the parties when we hit an impasse toward the end. So, Asha, I hope that's responsive to your question.
Yes, absolutely. Thank you so much.
Okay. Robin.
Thank you. Thank you, David. That sounds like your first round is building trust with the parties, essentially, which you need before you can do anything else.
Exactly.
The question that I had was with the example that you gave before of the large family mediation and the guy who was in your face and said that you'd actually made the situation worse. So what did you say to him?
I said to him, I don't always have the presence of mind to respond in a non-defensive way, but somehow I summoned the ability to do it in that instance. And I said, I'm really sorry to hear that. It's not my intention. Help me out. What are your thoughts about how I could be doing a better job here and how this process could be working better? And that engaged his system two circuits. And he started giving me some ideas, and it was really helpful. And later that day, we got the case settled. So I guess my comment for us all is that figuring out how to unblend from our jangly manager and firefighter parts, get them to take a step back and make some room for self-energy, for calm, curious, compassionate interaction. That's the goal. Robin, is that helpful?
Absolutely. The French have an expression, le mot de l'escalier, the word that you think of when
Yes.
you've left the conversation and you're in the staircase. Oh, I should have said this. And so if
Yes.
we can give ourselves room to access that in the moment, then we can.
Exactly.
Yeah.
And sometimes it means we have to take a break so we can go out in the hall and regain our composure. Now, I see three hands up, one from North Carolina, and the name isn't exactly clear, but you know who you are because you have your hand up. Then Jeremy, and then Rachel. Okay,
Hi,
so
hi, David.
it's like,
Vanessa.
Hi,
Millette from
Vanessa.
North Carolina. I
Hi.
have a question with reference to uh how do you have any tips for when the parties are what we call monetarily too far apart? They just can't close, we cannot seem to close the gap. One party wants what I call a large figure, large amount, and the other party is already saying we're not in that range. We're looking at it from a nominal perspective.
Yeah. Oh, great question. So let me just offer three um, ideas that I find useful when that's the problem. And then we'll get to the next two questions. So one thing we can do is see if the parties are interested in non-binding case evaluation. Or if we've diagnosed the gap, the settlement gap, as
Hmm.
having to do with what they think is the expected value of the case evaluation can help. And I've often seen parties, and I coach them to consider doing this, to say to the other side, look, you're at 1 million, we're offering 75,000. We're willing to settle for that. But if you're not willing to come down to 75,000, we suggest jointly hiring someone to do non-binding case evaluation, because we think the case evaluator is going to say this case is not even worth $75,000. And then the other side usually says, no, we're not interested in case evaluation.
Hmm.
But it enables the $75,000 proposal to have a little bit more credibility because that party has the courage of their convictions. Um, Second, arbitration is sometimes a useful tool. It may be more cost effective than going to trial, may be faster. And I find that parties typically don't want to do that because they don't want to give up control of the outcome. But it's helpful to give people, options. And then there's, if the bookends move close enough, I mentioned the mediator's proposal. So those are three techniques that can be used to deal with situations when the parties are far apart. I highly recommend doing a mediator's proposal when parties are closer together. But I've had cases where they're miles apart and they wanted a mediator's proposal. I did it and it actually worked. So I hope that's helpful,
Yes,
Vanessa.
it is. Thank you.
Jeremy, and I see you're in your car.
Yeah, I'm
Let's see.
sorry.
That's all
You've
right.
been
It looks like you have both hands on the wheel, so that's
I
good.
am, and you've been great company for a long drive. So thank you so much, David. So David, I've been thinking a lot about well, two things. How do you focus attention? And it sounds like a lot of the techniques you're using is helping people focus their attention. And the other thing is social plasticity. How do you get people to kind of think in a group behavior differently? And that got me thinking when you were talking about your parts technique. How often have you done that in joint session? Have you been able to kind of ask a person, between the part of you that feels fairness is this way and the other side is pragmatic and practicality? Maybe that one's a bit too personal, but have you ever tried this in joint session? And has that kind of triggered something the other side? Because I can just see how it could be a very relevant way to create a common kind of human behavior script
Yeah,
between the people.
great question. Thank you for that. Um, I would say that because most of the time in divorce and family mediation, I'm meeting with the parties together. I am doing exactly that in mixed company and talking about parts. But I also do it in caucus in those family cases. But in the other cases, the business and employment, construction, intellectual property, insurance, cases like that, where the parties have lawyered up, my experience is they typically don't want to be vulnerable and talk about what's going on inside them in the presence of the other side and in the presence of opposing counsel. And so it's much more a function of caucus session. But that's also a function of the fact that in commercial employment, tort, and similar cases, uh, at least in the legal culture that I work in, most of what we're doing is in caucus. Um, so I hope that's responsive, Jeremy. And I'd welcome a chance to further that conversation if you'd like.
Thank you.
Okay, so Buffalo, New York. Help me out with the correct pronunciation of your first name.
You are right. It's Rahel. Thank you so much for
Sure.
asking. I appreciate that.
And then Rachel is next after you. Go ahead.
And thank you very much for this excellent presentation. It's really appreciated. My question is, I know in one of your examples, you used a family value to bring parties together. And I was just curious to see what were your observations to let you know that is one of the core values for that particular family, to help you kind of bring them together and make progress.
Yeah, so in that particular case, it was partly guesswork on my part. And the fact that they were willing to make the commitment to, on short notice, all come to, my house out in the suburbs of Boston. And it was apparent to me that there were strong attractive forces as opposed to centrifugal forces. I guess those are called centripetal forces. There was a lot of glue to work with, and they clearly cared about each other. I guess I had gleaned enough from some emails back and forth that these family members deeply loved each other and cared about each other. So I took a little risk, and also, if you do that exercise, it seems to me you have to be willing to interrupt it if someone decides to not adhere to the prompt and say, well, I just heard my dad say that honesty is a family value, but let me tell you, and I'd say, no, hang on a sec. Let's talk about the values, and then we'll talk about the extent to which anyone has deviated from them. Fortunately, I didn't have to do that, but I think that's part of our job as mediators, is to interrupt situations where people are inflicting harm on each other.
Absolutely.
Does that make sense, Rahel?
It does. It does. I was just curious, is that something you do for all of your cases? Is that a skill that is within you that you recognize and utilize a lot?
Well, there's a part of me that's very conflict avoidant and risk averse. And so that causes me to jump in and interrupt when I see people kind of banging into each other. So that's a part. And then I have another part that says sometimes they need to bang the pans a little bit before we get a settlement. So everybody's got their own threshold of tolerance for for risk and conflict. So I hope that's helpful, Rahel.
Very helpful. Thank you very much. I really appreciate this. And thank you, everyone's contributions too.
Thank you. I want to be respectful of the time of the organizers here. We have one question, and then Maria, I'm looking over to you, and to Nikki. Maybe we'll wrap this up. Rachel, you got the last question here.
Thank you so much. I'll be very quick. Thank you for your time. I appreciate it. I'm calling in from the DC area. You mentioned a mediator proposal and how you meet with both parties separately. My question is, are you leading that with curiosity when you're offering a mediator proposal and they both agree? But what if they disagree and you've tried all the options and you explored everything and they're just still not ready yet? Do you come back and reoffer and re-engage, or what is your process? Thank you.
So if one side wants a mediator's proposal and the other doesn't, they're not going to get a mediator's proposal from me. That's not how it works. So maybe I'll go back to my office, get a copy of the book, The Art of Impasse-Breaking, and I'll hand it out and say, let's look in this book together and see if, since a mediator's proposal is not something both sides want, what would be a good technique? And then just be silent for a moment and see what they say. This is a process, as we all know, that we co-create with the parties, and if they're lawyers, with their lawyers also. So the mediator doesn't have to have all the answers, but we do have to have some good questions. And sometimes in the situation you described, Rachel, the question is, well, what would be a good process here? Who are the right people to be having this conversation? Which of the three tables should we be meeting at? Let's step up to the balcony together, diagnose the reasons for this impasse, and see if we can strategize together. And that's why my joint session with just the lawyers sometimes can be really fruitful, because they have a much better sense than I do of who their clients are and what might be workable for them. So I want to enlist them and their skills and their knowledge in helping to design an impasse breaking technique. So Rachel, is that responsive to your question?
Absolutely. Thank you so much. And I also sent you to connect on LinkedIn. Thank you.
Maria and Nikki, over to you.
Well, thank you so much, David. As you can tell, we could be here for hours. You have really given us an amazingly informative and stimulating session this morning. Once you get a chance to take a look at all of the accolades in the chat, it will fill your heart up. People were just pouring out gratitude for your thoughts and contributions this morning to enhancing our field. Thank you, thank you, thank you. And thank you, Nikki, for an amazing job again in filling up the chat with all the resources. We will include all of this in the postings on the YouTube channel. Make sure if you want to watch this video again to tune in, and you'll see the slides as well as the chat. And with that, we will sign off as I posted in the chat next month's. As a speaker will be Chuck Doran, who will talk about the organizational ombuds work. Thank you so much, everyone, and look forward to seeing you next month.
Thank you, everybody.
Thanks again,
Bye-bye.
David.